Thank you, Julia. I appreciate the invitation from the library to come and speak to the community. I view my role as an attorney not only to do the transactional work, but to make law and legal solutions accessible and understandable to regular people. So that's my goal. If I start talking in legalese or unusual language, raise your hand and stop me, but I try to make things very understandable and helpful and accessible to regular people in the community. So it's my pleasure to be able to come and talk to you tonight about planning for the unexpected. And so really there's two major parts of what I do in planning. One is the documents for your estate plan, and then the other is dealing with the aftermath after we've lost someone close to us and what we have to do to work through that. So I'm going to talk first about estate planning. What is estate planning? An estate plan is a set of documents. So it's your will, your power of attorney, your healthcare power of attorney. Estate planning is also a process. So it's going through analyzing your family situation, your assets, your goals, and your needs, and how we can put a plan in place to provide for the effective and orderly transition of your assets after you have died. So I mentioned a few of the documents already that are part of every estate plan. The basic documents that everybody needs include a will, and you've heard of this, your last will and testament. In your will, you do some really important things. So people think about the part of deciding who gets what, who's going to inherit from me. Often, your will does very little of that, because often you have beneficiary designations on many of your assets. But the will serves some other very important purposes. The will names an executor. Your executor is the person that has certain legal authorities to handle different matters and transactions after your death. They step into your legal shoes, that your beneficiaries or your heirs don't have that same purpose or that same function. So the executor can deal with paperwork, IRS, lawsuits, signing documents after you've passed away, because you're no longer here to do that. In your will, you also can name a guardian, so the legal representative who can be responsible for your minor children or your incapacitated or disabled children. So you have the control, and that's a document where you have the power to name and designate after my death, this is the person that will step into my shoes to take on this caregiver role. And then in addition, your will designates who the people are that will inherit from you after your death. Ohio, like every state, has a statute, a piece of law that says, if you have no will, who inherits? Many of us, that may fit, many of us, that may not. So in your will, you can define who inherits and in what proportions. The will governs whatever assets don't have a joint owner and don't have a designated beneficiary. Deeds are another piece of paper, another document that I create a lot of that helps with estate planning. Ohio is a very family-friendly state for the law. There's a lot that we can do to keep things streamlined, avoid going through the probate process. Probate process is going to court, taking your will to the court and saying, probate judge, please enforce my will, my wishes. Appoint my executor to handle these things for me and apply the words that I put in this document. For many of us, and in many situations, we can designate our beneficiaries or our heirs to inherit the property without going through that process. And so one thing that you may do is make sure you have survivorship terms in your deed. If more than one person owns it, that the surviving person will continue to own it. You can name a designated beneficiary or group of beneficiaries for your real estate. And so you can set things up so that your home or your real property also can pass directly upon your death to your named beneficiaries without going through the court process, if it makes sense for you, for your family, and for your estate. Other beneficiary designations I've touched on, make sure that they're up to date. Your life insurance, your retirement accounts, IRAs, investment accounts. So that's something that we talk about during the process of estate planning. I don't usually deal with your life insurance company myself, but I said it's both the documents and the process. So that's part of the process, is making sure that the assets wrap in together with your plan so that your wishes and your goals are followed. I mentioned at the beginning the documents that everybody should have. So not only a will, and that's what we think about. We think about, oh, if I die, then what? But also, what happens if you need assistance while you're still alive? I think that's as important, if not more important for many of us, than designating what happens after we die. So those lifetime documents, there's two kinds of powers of attorney. We have what's called a durable general power of attorney, in which you can name somebody that's able to handle legal and financial transactions for you while you're alive. And so you can choose your own person and give them as broad or as narrow of authority as you feel is appropriate in consultation with your advisor to make sure that your matters can be effectively handled if you're not able to do so. And that might be short-term, just not available, or injured, or it can be long-term. You can lose your capacity and still have your person handling your affairs privately for the rest of your life. Another document is the healthcare power of attorney. Who's your medical decision maker? Who's the point person to talk to the doctors, make decisions, receive information, and communicate it back to the rest of your important people? And so that's a document that you create, and you choose the person. With the healthcare power of attorney, many people sign or consider signing a living will. The living will is a document where you make some of your own end-of-life decisions. So a lot of these sometimes are tough conversations, and that's part of the process. Again, we have the document, we have the process. Sometimes it's tough conversations, but a living will says, if I'm terminal, I'm at the end of my life, I'm going to die soon no matter what, or if I've lost all of my higher brain function, I cannot think, recognize people, I'm permanently unaware of myself and my surroundings, and I cannot experience pain, I'm telling my doctor myself, I don't want life support machines and feeding tubes. I want comfort care only and let me die naturally. Don't postpone my death. If that fits your wishes and you have that document, then your doctors aren't asking your spouse, your children, your best friend, or your loved ones, what would Hillary have wanted in this situation? So those are the basic documents that most people have. Another part of estate planning documents that you may have heard of and certainly have a place are trusts. And there are as many kinds of trusts as there are family and financial situations. We can do a lot of things with trusts. Prior to 2013, a lot of people had trusts because we had a estate tax in Ohio. We had a estate tax on estates that exceeded $338,000. And that was including your house, your retirement, your investments. So a lot of people were concerned about estate tax. January 1st of 2013, Ohio got rid of estate tax completely. And currently, as of today, February 2022, our federal estate tax exemption is over $12 million per person. If you're married, it's $24 million. So not too many of us have to worry about estate tax anymore. So we're not using trusts for estate tax a lot, but they still have a place. So examples of where a trust might have a good place is if you own a small business, you have out-of-state real estate, you have a blended family and you want to provide for your spouse, but there's assets you want to preserve for your children when you're both gone. You have a disabled beneficiary, somebody who needs some help, some monitoring, or needs to stay eligible for their benefits that they already receive. You don't want to take away all of somebody's support and programming. You want your inheritance for them to supplement what they have, not to take it away. So there's a lot of places for trusts, and there's some more advanced planning that we do sometimes for people later in life that are concerned about long-term care expenses, but don't want to just give their assets completely to somebody else's control. There's a lot of purposes for trusts, but my perspective is they have to have a purpose. They have to be worth it. They're more work for you as decision makers. They're more work for me in creating the documents. So they certainly have a place, and that's a individual discussion for each person in their family situation. The strategy, and so things that come up, why do we need to take another look at our estate plan? When is it time to make changes? People ask me all the time, well, it's been 5 years, do I need to redo my estate plan? Maybe, maybe not. So what types of things make us have to look at changing your estate plan or making a new estate plan? We go through this strategy process and this planning conference. What has changed in your family structure? What has changed in your goals or your plans? What has changed as far as your asset structure that might indicate a need to make some updates? And so sometimes passage of time, as we age, the people that we named in our will 20 years ago have also aged. And so maybe they're not the right person to be the executor anymore. Or maybe our kids aren't 4 anymore, they're 34, and we don't need to worry about a guardian anymore. So sometimes just the passage of time, life evolves. Changes in law and changes in tax law. So I mentioned that change in 2013 on the state tax law. A lot of people have very complicated estate plans that they don't need that complexity anymore. So we can add a lot of simplicity. Or the estate tax law could change and it could put some of us back in a situation where we're concerned about estate taxes. It's a conversation to have. I mentioned in the outline when your children reach adulthood. So maybe I've named my sibling or my spouse or even my parent as my power of attorney. Once my child's an adult, there comes a point where your child is the person that you're naming to start taking on those responsibilities if and when you're unable to do so. Definitely when you've moved. So I mentioned Ohio is a very family-friendly state. You hear about probate, and I'll talk about that process a little bit more in the what happens after somebody passes away. You hear a lot about avoiding probate, maybe some horror stories about how long it took, how expensive it was. They're all true. That's true. But Ohio's way better than most states. I'm also licensed in Florida. I don't go down to Florida and practice, but we have enough people in Ohio that like to spend time in Florida, want to retire to Florida, have second homes in Florida, that it was worthwhile for me to learn that law. Florida probate takes a lot longer and is a lot less family-friendly than Ohio. Ohio, really, the goal is to come to conclusion quickly, to protect your family. And so if you've moved to Ohio from another state that has more complicated laws or has very different looking documents, the simplicity and the streamlined version of Ohio documents can be well worth making the change. So I think it's important. One of the things that I do, and one of the things I think is important for people, is to really have a team approach when we're looking at your estate planning. And like I said at the beginning, it's the documents and the process. So if you work with a financial advisor, your financial advisor should work with you and with your lawyer, and sometimes with your tax professional or your investment professional, to make sure that all of these things work together and that you don't have a will that says one thing and a beneficiary designation that says another. So that team approach, making sure that you, your professionals, your documents all are on the same page, will make sure that your wishes are carried out and you're protected throughout the rest of your life, and your wishes are protected after you're gone. And so the second part of the presentation is what I think is of concern to a lot of people, and one of the things that Julia brought up as one of the concerns and goals for this talk. And that's, what do we do when someone has passed away? What do we do when someone close to us has died? I think we often hear a lot of, we call them street corner lawyers, a lot of advice of things that you get told you should run out and do, and some of those things are not beneficial at best and illegal at worst. So really, the first thing that we do, and what we planning lawyers would advise somebody to do, is to go through the grieving process. So the first thing to do is not to run to the bank and drain accounts. The first thing to do is not necessarily to try to do documents or run the will down to the probate court. Frankly, you can't do anything until the death certificate is issued. So the first thing that we do is we have to make final arrangements. And so sometimes that falls to the survivors completely. Sometimes the person who has passed away has made some pre-planning, some pre-arrangements, or given some instructions. So the first thing that you want to do is find out, do we have arrangements? Do we have a pre-planned funeral? Do we have a burial plot? What are the arrangements going to be? What funeral home are we going to work with? What is this going to look like? Another important thing to do when you are going through the process, if you're responsible for the funeral and the estate, is to request several death certificates. So typically one is not enough. Typically you're going to need at least 3, 5, sometimes more.
Should they be certified?
They all will be, when you request them from the funeral home, they will be certified copies. And so many times you need to have, they look like originals. You need to have an original. And many times you submit them and they'll come back to you, and sometimes they keep them. And it depends on what you're doing and what your process is. The DMV, when you go to transfer a car title, keeps all of your original documents every time. So if you have court papers, death certificates, everything that you have, they keep every time. And if you have to go down and transfer 4 cars, you have to have 4 sets of certified copies every time. So the next thing you do, so you get through the funeral. Northeast Ohio, make sure the heat is on. If it's summer in Northeast Ohio, make sure the air conditioning is turned very warm and you're saving some money on utility bills. Try to lock up and protect real estate, houses, cars, valuables. Just try to protect them. One thing that people don't recognize is you may be named as the executor in a will, or you may be the sole or the primary next of kin, but until you either take control of an asset by nature of the ownership designation, or you are appointed the executor by the probate court, you don't have a legal authority to the property. So as a family, as a friend, as a next of kin, try to secure it, but it's not yours to control until you have legal authority to it. So I mentioned that I have it on here on number 3, take some time to grieve. Bills and wills and all those things, they're gonna wait until at least you've gotten through the funeral and the memorial process. One thing you should be mindful of if you don't have it and don't know where it is, look for the documents. Look to see, was there a funeral designation? Was there a will? What documents, what assets, what bank statements do we have? What things are you going to need to worry about taking care of? Start holding on to the mail or have somebody hold on to the mail. It'll start overflowing the mailbox. Well, just put it somewhere safe. That your mail is going to give you a lot of information as to the things that you need to take care of when you're administering the estate of somebody that's passed away. But I caution you, don't necessarily pay all the bills. If they're not your bill in your name, you might not have to pay them. So wait and consult with somebody that knows what they're talking about before you start paying off bills that may or may not be necessary. Now, some things are necessary, right? Keeping the heat on in February in Twinsburg, Ohio is necessary. So pay the heat bill. But maybe you don't have to pay the credit card bill if it's not in your name. I mentioned in there, I already went through, you're not the executor, even if the will says you are, until you've gone to court and been appointed the executor. So I suggest have a consultation with a lawyer that does probate. Sometimes it's simple enough that you can do it yourself. There's forms. There's people at the court that will tell you what forms you need. Sometimes there's complexities that you need some advice and you need some support. Sometimes the technical burden, the paperwork burden, is more than you want to bear on top of the emotional burden. So it's good to have someone that actually knows what they're doing, and particularly somebody that practices in the court in the county in which you have to administer the estate. So if your loved one is in Columbus, in Franklin County, I'm not going to be your best lawyer to handle the estate. I can give you some advice and tell you what might need to happen, but somebody that's regularly in Franklin County Probate Court is going to be a good fit for you. The county courts, although we're all under one set of laws, everybody has their own set of rules. So how things need to be handled can change county to county. So it's important, get some advice. You have professionals in your midst that you can rely on. So that's a good thing to do, is find out, do I need to go to probate court at all? Right? So that's the first inquiry. Do we even need this? If you have a beneficiary, if there's beneficiaries named on all of the assets, on the house, on the car, on the financial assets, you might not need to file a probate estate at all. So that's inquiry 1. Do we even need to? Inquiry 2, when should we? So timing matters. Sometimes it's not a great idea to file the probate estate right away. Sometimes it's better to wait. And so somebody that has experience with regularly handling that, just the door, can advise you what the right timing is for opening an estate. Keep track of your expenses. If you are paying for things on behalf of the deceased person or on behalf of their estate, keep track of that. So there is a specific law on the priority of who gets paid when from estate assets. And if there's a small amount of estate assets, the people that got the estate handled are going to be entitled to certain reimbursements before, like the Visa bill, for example, gets paid. So keep track of your expenses, your funeral bill that you may have paid, utilities that you're keeping on to protect the estate's property, legal fees. may be entitled to reimbursement for all of those things. So keep them, keep it organized and separate. If you do need to open an estate bank account, know that you need to have a separate tax ID number. The estate's not you. The estate is its own entity. And so it's a relatively simple process, but just that's something that's important to do because administering the estate is a formal process. And again, you keep it separate. Be prepared to file an income tax return on behalf of the deceased person if in fact they had taxable income. And that's one of the less fun parts of my job. I have several estates right now where returns haven't been filed in years. And we don't have the information, so we're tracking it down. And that tracking of information gets harder as time passes because people do more things electronically. And what we used to have in paper is now in email. And how easy do you think it is to access somebody else's email account? Right, not easy. And let me tell you something else. I worked with a team of lawyers in 2014 to develop some language that we've added to our wills and powers of attorney to address these things specifically. Because even though Ohio law has caught up a little bit and says your agent under power of attorney and your executor are entitled to legal access to your digital assets after you die, your passwords, your online banking, your cloud. I mean, can you imagine? That was a nightmare in 2013 when we didn't have any law on it, and you had all your pictures stored in the cloud, and nobody could get into the cloud and get your pictures, and then they would just delete them. Verizon would delete them. So even though we have law, Apple says, and AOL says, and PayPal says, we're not bound by Ohio law. We have a contract with John Smith. If John Smith didn't say Hillary's allowed to access his password, we're not giving it to you. So things like that, working our way through and trying to find this information can be challenging. And so be aware, if you're appointed executor, you may have this obligation to file a tax return, and you might have to do some extra work to track down the assets. So I mentioned, I've talked about this probate process, going to probate court. What is this? What is this process of estate administration? And what's my role, or what might be your role if you're responsible for winding down somebody's estate? So this whole administration concept, it might be a will in probate court. It might be handling a trust, which is a lot of these same duties, but it's handled privately, not through the court, not with court supervision. And it also involves these beneficiary designations that I talked about before. Somebody's filing the claim with the life insurance. Somebody's filing the beneficiary claims with their retirement accounts. Somebody has to file the death certificate in the deed records, or go down to the DMV and change the title to the cars. So sometimes it's these beneficiary designations, claim forms, the probate court administration of the will, if that's necessary, required, or beneficial. That's a very formal process. We have to itemize, appraise, place values on assets. We have to identify creditors, whether they're valid or not, whether we have to pay them or not. And the executor has to account to the court. It's a very detailed and formal process. So you don't just, as executor, take these assets and do what you want with them. You really don't have any discretion. You don't get to pick and choose which child or grandchild deserves a bigger share than the others. You have to do only what the will and the court say. And so we have these forms, but there's required timing and details in the documentation. So we file this inventory with the court. We tell the court, what assets are we administering in this estate? What are we asking for authority to do? And you file that with the court. Once that's approved, you'll have notified, located the next of kin, the family members, notified the court of that, identify the assets and liabilities, and you have to go through this whole step-by-step process before we get to the point of distributing the estate. You have to notify the family members of each step along the way, give them the opportunity to review what you're filing, to object. I might file an inventory and say the 2015 Ford is in the estate, and Johnny pops up and says, no, that's my car. Here's the title, it's really mine, it's not an estate asset anymore. So they can object to the inventory, and it gets us to clarity. And when we get to the end, then you make the distributions, and you have to file an accounting back with the court as well. And say to the court, I as executor received all of these assets, paid all of these bills, and distributed to the beneficiaries. And not until that's done does the court release you of your obligations as the executor? There's also a couple other kinds of probate administration. It's important to note there are some shorter forms of probate administration for small estates or small assets. And the amount varies depending on whether or not it's a spouse that's receiving the assets or non-spouse. But when you have a small estate, there's things we can do that are very simple to move. When there's a car and a tax refund check, we don't have to go through the whole process. And that's something else that, being able to talk to somebody that regularly does this might be able to advise you the best way to move forward with that. The trust administration I touched on a little bit before. Trusts are handled privately, so typically privately and outside of the probate court. And think of the word trust. You're placing your trust in someone, a trustee, to handle all of these things after you have passed away. And to the trustee, their actions are governed by a contract, a trust document that you created, a packet of instructions that you have given to them. And then they have some obligations as a fiduciary, a trustworthy person under law. But the process is very different. It's a little less formal because it's not subject to the court supervision. So a trustee still has to gather the assets that are subject to the trust, still has to notify the beneficiaries of the existence of the trust, and has to account to the beneficiaries on an annual basis. But they don't have to file things with the court. And so they can have some more level of discretion, some more level of informal relationships and reporting for a lot of the processes. The processes can be more simple, sometimes more time and cost efficient, and certainly more private. So to the extent that that's important to you, that's a valuable benefit you get from a trust as well. The trustee usually works as a team with a lawyer, an accountant, and often an investment advisor if there are investable assets to support them in their role of the trustee so that they know they're doing things in accordance with the law and the fiduciary expectations. Fiduciary is an obligation to put somebody else's interests above your own, and that's a trustee and an executor both have that responsibility. They're not there to deal with or benefit themselves. They're there to make sure that this estate or this trust is handled in the appropriate manner and the assets get to the ultimate beneficiaries. Doing okay on time, I think.
Yeah.
One of the other things I wanted to touch on was how do we start or make funeral arrangements in Ohio? And so I mentioned Ohio lovely, lots of statutes, lots of laws that are written. They have laws on who would inherit if you don't designate who inherits. They have laws on who is allowed to make decisions for you if you haven't designated someone. So one of the things that has been added to this plan set of documents in recent years, Ohio adopted a law that allows you to designate a representative to handle the disposition of your remains and to make arrangements for your funeral. And so if you have designated a representative, and we often do that in a standalone document, because like I said, you may not look at the will until after the funeral. Often, we don't look at the will and the financial documents until after the funeral. So we have a standalone document that's now authorized in Ohio where you can name a representative who has the right to control your final arrangements and the disposition of your remains. You can give as much or as little detail as how you want that to look in that document, and your designation is legally binding. So if you don't choose someone, then the law says who gets to make these decisions for you. And so if you have not declared a representative, a lot of fuzz again. If you're married, your spouse is that person. So if you're married in Ohio, your spouse is your sole next of kin. They are the decision maker. If you don't have a spouse, your child or children, and here's where it gets tough. If you have more than one child, all of your children have to agree. And if all of your children don't show up or don't agree, then what? Then we're waiting. Then the funeral director doesn't move forward. Then, ultimately, if we can't come to some agreement, we end up going to court and getting some instruction from the court. And that's, rare, but that would be an awful outcome. If you don't have children, the next person with authority would be your parents. And this is, interestingly, this parallels the who would inherit if you don't have a will. And we don't think about that when we are adults. We don't think about the fact that if we pass away without spouse and children, our inheritance goes up. If you still have one living parent or more than one living parent, the inheritance goes up. So does this right to control your funeral and the disposition of your remains. Go to your parents. If your parents are, and they have to, again, they have to agree. So, 50% of marriages these days end in divorce. That might not always be so easy. Just like your children may not all agree, your parents may not agree. Next, if you don't have spouse, children, or parents, then it's your siblings. And again, all by agreement. Uniform agreement, not majority rule. They all have to agree. And if somebody doesn't show up or participate, then things freeze. If you don't have siblings, then your grandparent or grandparents. If you don't have any of them, your grandchildren if you have any. Again, by agreement, not by majority. And then there's one more level of family next of kin, which is defined under Ohio statute. So that's the descendants of your grandparents. Your aunts and uncles, at that level, all of them by agreement, or nieces and nephews. Here's where it gets fun. If you don't have family members that step up and take responsibility for the disposition of your remains and arranging your funeral, any person willing to assume the right to control the disposition of your remains, including a funeral director, can be the decider. Whoever has custody of your body can be the deciding factor and arrange your funeral. And then the last part is if there's nobody and your body never got to a funeral home and there's nobody steps up, then a state official is responsible for it. But I find that one last section, I find that a little concerning because then who's responsible to pay for that? They bill your estate. So, to the extent that you have wishes, it's important to communicate them. Even if you don't put it all in writing, even if the person under the statute, you're married and it's your spouse, that's fine. Have a conversation. It's very valuable to your survivors to have a conversation about what does this look like? What should happen when I die? And so that's a couple parts. One is, what does my funeral look like? Do I want to be cremated? Do I want to be buried? Do I have a certain cemetery I would like to be buried in? Do I have any preferences? Do I want some religious observance? Do I want a memorial service? What does that look like? Does it involve food? Does it involve music? Have that conversation. It's interesting to see the different responses when people have this uncomfortable but open conversation within their family, and the variety from I want the simplest nothing to I want several days of viewings and full ceremonies and a fancy headstone engraved with my image and a poem. You're laughing. This is true. And you can have siblings or spouses in the same family that have these different wishes. It's very empowering to your survivors to know what your wishes are, because when we go to make the arrangements, somebody's selling us the arrangements, frankly, and that's their job. And so if you've expressed what your wishes are, it's very easy to follow when you know what your loved one wants. It's very hard to make those decisions when you have no idea. So what does that part look like is a conversation that you should have with your loved ones. Many times, the funeral home won't make arrangements without knowing how they're going to get paid. And so you personally, whether or not you're responsible for the estate, are going to be on the hook. Whoever makes the arrangements is on the hook for paying that. So you can also, in your declaration, these are my wishes, you can say these are the sources of payment. So here's this account that I'm going to make my daughter the beneficiary of this account, and I'm going to try to always keep $10,000 in there because that's going to pay for my funeral. Or you can have a life insurance policy, or you can have a prepaid arrangement with a funeral home, which is still really life insurance, and is transferable, so it's not a bad thing to do. Or it's going to get paid from your estate, if you have one. If you don't have a probate estate, then it's whoever made the arrangements is responsible for that. So these conversations, I encourage people to have, not only about what does my final arrangements look like, but where are these documents? If something happens to you, does somebody know where to find your will? Where to find your life insurance policies? Where to find bank statements, passwords, which none of us have written down on documents. Where do they find this stuff? If you have it in a safe deposit box at the bank, guess who's not finding it? Anyone but you. You're exactly a safe in your home, or a folder, or a binder, or a shelf. But have a little bit of conversation. What will be expected? What will be needed when I'm gone? You don't have to go into all the detail, who gets what and when, but where do we find the documents? Where do we find the information? Who should they talk to? You know, if you're handling the finances, make sure that the next person responsible knows who to talk to about your financial matters, who your doctor is, where to find the healthcare power of attorney, when an emergency comes up. So these conversations, they're not fun, they're not enjoyable, but they're super important and super valuable. And so that's, again, part of the process. So we start with the process, what do we have, what do we need, what are our goals? And we end the process with, what information do we need to share with our trusted people and our survivors, when and how? And that's how we close the loop on the planning process through the beginning part of the administration process. And I am right on time. It's 7:15. I welcome questions.